Thank you. Good afternoon, Your Honors, and may it please the Court. My name is Diane DeWolf. This is my colleague next to me, Bill Van Norwick from Ackerman. Next to him is Andrew Gracie from Peebles & Gracie. Together, we represent the appellant in this case, Treasure Chest Poker, and I'd like to reserve 5 minutes for rebuttal.
Right.
Your Honors, this case is not about lotteries. This is about free entertainment when prizes are involved.
Yeah, and I guess that's really the heart of it. Is they're trying to say it's a lottery, and
yes, Your Honor. The department is asking.
Is that it's not.
Exactly. The department is asking this court to take Little River, which is a case confined to lotteries, and expand it to all sorts of entertainment where prizes are awarded, and that includes all types of card games and any other type of entertainment that anyone can provide as long as prizes are awarded. We ask that the court exercise judicial restraint and not improperly expand Little River in that way for 3 reasons. 1, a lottery and a poker game are nothing alike. 2, the Florida legislature and the Florida Supreme Court have both recognized that while lottery is a form of gambling, not all gambling is a form of lottery. And 3rd, no court has ever held that a poker game is a lottery, and no court has ever held that a card game, when not played for money or other property, is gambling under the laws of the state. So I can address each one of those in turn. First,
isn't the goal of the, first of all, let me remark that the briefing on both sides was incredible. Isn't the idea of the Little River decision, pardon my voice, is that the activity and the consideration that's considered is to swell the patronage, is the whole concept of how they've been able to stay in business for a decade, is that they're paid a fee by a lodge or another kind of business to get people in the door. And once they're in the door, the hope is not that they get to shake hands with them, but instead is that they spend money while they're there to otherwise swell the number of people entering the door. And I'm having a difficult time, and what I need help on is how to distinguish our Supreme Court's case where, the methodology that was used, perhaps it wasn't the lottery where no purchase was necessary on bank night, where anyone that didn't have an admission can come in just before the few minutes before the drawing. I'm having a difficult time understanding the difference on how am I supposed to, within my own authority, revisit the Supreme Court's case, and it's almost like you're asking us to legislate this.
No, Your Honor, it's not. And if this court is to hold that the Little River opinion, which is meant to address lotteries, applies to all other sorts of card games, essentially every type of gambling and every sort of entertainment, this court would be exercising judicial activism and not restraint.
Tell me why.
Well, first of all, as I was saying, a poker game is fundamentally not a lottery, and a lottery involves absolutely no skills at all. All a person has to do is show up, get a ticket, enter a drawing, stand around and hope. It's antisocial. In poker is a social game. It's been played for a century, over a century. Presidents, this is in Judge Weinstein's opinion, presidents and Supreme Court justices have played poker for over a century. Lotteries are the most condemned form of gambling in our society, and for that reason, something less is required to trigger consideration for a lottery. And the Florida legislature and the Florida Supreme Court have both recognized that these are fundamentally different animals. Section 849, if you look at Chapter 849, you'll see that 849 is entitled Gambling. Now, within the gambling chapter, the legislature has separated out various sorts of gambling. There's separate subsections for bookmaking. There's separate subsections for lottery. In other words, lottery is a form of gambling, but not all gambling is a lottery. There's a separate section for pari-mutuel wagering is in a different section, and bingo is a different section. So all of these are types of gambling, but not all of these are lotteries. And the legislature, of course, has not defined these terms for us, so presumably we're supposed to have to understand what they mean, but the only place in Chapter 849 that card games are addressed is in the catch-all phrase, 84908, which is gambling. Now, because these terms are not defined under Chapter 849, the best that we could do is look at the jury instructions, which the Florida Supreme Court has established for each subsection of Chapter 849. And if we look at the jury instructions for lottery, which is Section 22.7, it explains that a lottery has three elements. It has a prize awarded by chance for consideration. It then goes on to explain what that consideration can be. That consideration can be one of two things. It can be one, a bet or a wager, which means a risk of money or property, or two, it can be a thing ventured. A thing ventured means it's not a risk of money or property. It can be in the form of time, inconvenience, effort, at the risk of foregone opportunities. Now, if one looks at the jury instruction for gambling, which again is the only place in Chapter 849 where card games are addressed, the jury instruction for gambling, Section 22.1, also has three elements. It says that we have engaged in a game of chance, risked money or property on the outcome of the game, and expected to gain or lose money on the outcome of the game. That's it. It doesn't say that you can play a card game just by showing up and that you've satisfied the consideration for a lottery by your time, effort, and inconvenience when you could have been doing something else. And if this court is to hold that, then all card games become lotteries. If prizes are awarded, that means we have no more bridge tournaments, no more hearts, no more spades, no more cribbage. And it doesn't just stop there. It doesn't stop with card games. It really is any form of entertainment. If prizes are awarded, if someone shows up when they could have been doing something else, that means the Florida Bar can no longer have their casino nights at the annual convention. And that means that establishments cannot hire entertainers for fear that that entertainer might give out prizes during the course of the evening. Suppose an establishment hires a rock band, and I think we cited this example in our brief, and that rock band gives out CDs and T-shirts and whatnot. The people that receive those, hoping to win a prize, could have been doing something else. Then we've expanded Little River to cover that as well.
If the consideration is the increase in revenue to the establishment that's hosting the game, increase in patronage, the consideration is going to one entity, but the prize is coming from a different entity. Does that make any difference? Does that factor into this at all?
Well, I think it does if we're still struggling with whether it's a lottery or not. One, to address your first point, there's nothing wrong with a business doing a promotion to swell its patronage.
Well, they have no problem with this.
Right.
It's just that they give a prize. That's the issue.
Right.
They want to give a prize. And the
Right.
prize goes to the winners, correct?
The prize goes to the
There's no
winner.
drawing for that.
There's no drawing.
You have to win to get a prize.
Exactly. And the reason this takes it out of the gambling statute as well is that there is absolutely no way to increase your chances of winning by buying anything. You
Right.
can't go and purchase, there's no cover charge, there's no cost at all to play these games, there's no minimum food or beverage purchase, there's no way to purchase something and get extra chances to win. This is purely on the skills. Everybody gets the same amount of chips, everybody sits it down, everybody plays poker, and the winner gets some sort of a prize. But exactly, Your Honor, the establishment who hires the entertainment is not giving out any prizes, and the entertainment here is not taking any money of any kind from the patrons to which it is awarding prizes.
Right. There's no argument that they're getting any consideration.
No.
No, but the promisor is the establishment that has paid a fee to the entertainment company, and that's an agency relationship in which they're giving out on behalf of the promisor the gift. Correct?
No, Your Honor, I don't think so.
So the promisor is the business that hires your company. Your company is paid a fee from the business, the promisor,
To provide entertainment.
to provide entertainment, and part of that entertainment is giving out gifts. Isn't that the same as the promisor, the business itself, giving out the gift?
Well, I think no, I don't think it is, and I think you have to look back. I think you have to look also at the rock band example that we mentioned before. A business can hire entertainment of any kind, and whether they give out entertainment or not shouldn't turn entertainment for a business is hoping to swell its profits into a lottery. Especially when that entertainment has nothing to do with drawings or tickets or chance or whatnot. Which brings me to my third point. If we can decide, and by the way, the department talked a lot about the predominant factor test and whether poker is predominantly a game of skill or a game of chance, and for our purposes here, it really doesn't matter. All this court has to recognize is that, like every other court in America who has addressed the issue, has recognized that there is some element of skill in the game of poker. And that takes it out of Little River, that takes it out of the lottery cases, that takes it out of the lottery statute, it takes it out of the lottery jury instruction. And so then we have to look at, is it gambling? And the gambling jury instruction says it's not gambling unless you've risked money or property on the outcome of the game, or you expected to gain or lose property on the outcome of the game. And we've cited several cases from the Florida Supreme Court that all have been gambling cases. They've all had to do with dice games. They've had to do with card games for money. And no court in the state has ever found that there was gambling present when no money or other property was risked on the outcome of the game. And I can save the rest of my time for rebuttal if you don't have any other questions. Thank you.
Okay, thank you.
Good morning. May it please the court. My name is Marissa Button. I'm here on behalf of the Department of Business and Professional Regulation, Division of Alcoholic Beverages and Tobacco. The division's position today is that the court should affirm the trial court's determination that Treasure Chest's conduct in hosting these free poker games at bars and taverns meets the definition of an illegal lottery. Clearly, through my opposing counsel's argument today and in the briefs, they feel like this would result in a slippery slope of any type of entertainment activity being considered an illegal lottery. And
why are they wrong about that?
And they're wrong about that because whether or not something is entertainment does not come into the court's analysis and whether it constitutes an illegal lottery. We look at the three elements of prize, chance, and consideration and make that determination. And in the courts in Little River and in Blackburn versus Ippolito in the second DCA, the courts looked at what was happening in terms of substance over form. And really, when they look at it that way, what's actually happening is that you meet the three elements. And the entertainment does not come into the analysis.
Is Little River's holding confined to lotteries?
Our argument is Little River's holding is confined to any activity that meets those three elements. And these free poker games...
So it's not confined by the facts of the case, which was a lottery? Is that the state's position?
The state's position is if any activity meets the elements set forth in Little River, it is an illegal lottery. Whether it's tickets drawn, whether it's a game, as in this instance, if those elements are met, it is an illegal lottery. And whether or not something is fun or entertaining, usually these activities are fun and entertaining. That doesn't change the long-standing case law in this regard.
So are all lotteries gambling? And is all gambling lotteries?
No. A lottery is a species of gambling. I'm sorry for interrupting. That's a part of the analysis.
What if people were coming in and playing Twister, and whoever won got a prize?
Well,
is that a lottery?
We go back and look at, arguably no, because you don't meet the element of chance.
Why?
If you've got the...
You spin...
How is that, come on.
But it's what predominates. And so when we look at the Rock Band sample given by
let's say
counsel,
they play Monopoly, and you get a prize.
there are game nights all over, board game nights in bars and restaurants and trivia.
Okay.
And part of that analysis goes to whether prize, chance, and consideration.
Okay, let's talk about Monopoly then.
Sure.
You mentioned trivia. You get a prize. Come in, it's trivia night.
Trivia night, 80s trivia night. Come and answer the question. You rely on your skill as a player to answer the question that's being posed to you. And in the Rock Band example, I want to make a clear distinction here. The reason that people
in poker, you're relying on your skill. The element of chance is what cards you get. Well, the element of chance in trivia is what questions you get.
And that's exactly why the predominant factor in the American rule is so important in this case. Because unlike what opposing counsel has said, it doesn't matter whether or not skill is an element. Your hand depends on the flip of the card, whether it's Goldfish, whether it's Bridge, whether it's any card game.
So wait a second. Now I'm concerned. I wasn't concerned until you just said that. These trivia nights that you have at Buffalo Wild Wings, where you're given an electronic thing, where you have to push A, B, C, or D based on the question out there, and you're given a certain number of points. And the whole point of that game is for you to stay longer, eat more, and consume more, beverages. That falls under exactly what you have said is illegal. That is troubling to me.
And I disagree, Your Honor, because you look at...
Tell me why. It's chance. It involves some skill. You have to have some knowledge of trivia. There's a certain amount of chance as to what questions pop up in the algorithm that day. You're competing against other individuals for a certain number of points. Tell me the difference.
You get to select what type of trivia you are engaging in.
No.
The chance.
How do you get to select your questions? The only way you select your questions is whether or not you show up.
And maybe we're thinking about different types of trivia, but I go to trivia night knowing it's 80s trivia night.
No,
I know a lot about 80s trivia.
No, it's just say it's a
trivia.
Let's just say it's a generic thing where any trivia question could come up. Have the establishments throughout our state been fundamentally committing this misdemeanor throughout the state of Florida on these trivia nights?
Well, Your Honor, when we look at the prize chance consideration, it may be deemed as such, but what the court says in its analysis is that you look at it in light of the substance over the form. And in poker, in free poker, it's titled poker. People come into that situation knowing that they have the opportunity under the record. The prizes offered are substantial. Page 35 of the record. Free trips to Vegas, gift certificates, more chips to continue playing.
Where does it say that the value of the prizes is applicable? Where is that in the test?
It's not in the test of offer, prize, or consideration, but when you look at whether or not that makes the person come and stay and play is the determination. So if you play free trivia night and you get some type of prize.
A t-shirt.
Sure, a t-shirt.
Free pitcher of beer.
And you would do that analysis and say, okay, is that enough to make the person stay or not? The incentive.
So the state of Florida knows it when they see it.
Well, Your Honor, no, the courts have said we don't do a specific definition of lottery other than these elements for the very reason that once you define it, any type of ingenious individual can say, I'm going to create this type of event to get around it. Just like offering a event like this and having a third party come in and give the prize.
The problem is that it's poker.
Well,
if we switched it to trivia and you gave these big prizes, it would be okay. Or if we switched it to go fish and you gave these prizes, it would be okay.
The problem is that it's a game of chance.
Poker.
The problem is that it's a game of chance. And your hand is determined by the flip of the card.
Lives or dies on our concluding that poker is predominantly a game of chance.
It's all a part of the analysis, Your Honor. They have to meet all of those three elements, and so yes, that's a part of the argument. But that's why we say it's different.
Judge Black's question is very important, at least in my decisional process. Mm-hmm. Can you answer his question? It seems like a yes or no question.
Yes, it does depend on that, and here's why. Obviously, it comes into the analysis of the elements.
You're analogizing poker to a pure draw chance lottery, as in the Supreme Court case. But you're saying, your argument is that poker is essentially a lottery. It's chance. It's predominantly chance.
It's predominantly chance, and that's the key word.
If I understood opposing counsel correctly, and she's going to have another opportunity in a minute. Her argument is that if it's in any level skill, then it takes it outside of the lottery.
Yes, and
that is her argument.
Yes, and we absolutely disagree with that. That would be the European rule. And
so what is the basis for your interpretation? The
basis of our interpretation is that Florida should follow the more restrictive American rule and predominant chance test, which throughout our Attorney General's advisory opinions on whether something constitutes a lottery, they have applied. Other jurisdictions that are similarly restrictive and conservative as to gambling in the United States also apply this test. So when we combine that with how Florida views the situation, and that's really how Florida originally made their determination as to what elements constitute a lottery, looking at other jurisdictions similarly situated, it makes sense to apply this predominant factor test. We would say, so all the things considered, that's how that element is met. We believe the consideration element is clearly met because the event is intended to swell the patronage. That goes back to Your Honor's question about, does it matter who's giving the prize? Does it matter who's getting the benefit? Part of the reason, as I said before, that our courts have said we don't specifically define this outright is because...
Perfect segue. Please address briefly the constitutional argument as to void for vagueness.
Our position is, obviously, when a statute has been alleged to be void for vagueness, the courts can look to previous judicial interpretations of those terms. And here, this is not void for vagueness. Little River had said, here's how we look at it. It exists if we have these three elements. Blackburn versus Ippolito, the same thing. The way the statute existed, both in 1939, I think 1977 for Blackburn versus Ippolito, the statutes for lottery, all the statutes essentially were substantially similar to how they are today. And in each time where the legislature has either reenacted or minimally amended, they have kept the statute the same way. And I think it goes back to that reasoning. You have to be able to have the flexibility with understanding Florida's restrictive look on gambling and how the state has a broad authority over it and its police power to be able to capture these activities. And in this situation, the activity meets that.
So the legislature then, your argument is that the legislature has intentionally not defined a criminal activity because it needs flexibility.
The legislature has accepted the court's interpretation of what the elements are that define it. That's my argument.
I understand.
They accept the judicial interpretation set forth previously. Briefly, and I wanted to address this, it didn't fully come up in co-counsel's argument, but when we talk about the game of chance by lot, that violation as well, there's been some assertion that either there has to be a bet or a wager or something like that to occur to result in that violation. In the Little River case, the underlying court said that the activity was a violation of an illegal lottery and an illegal game of chance by lot, based on the facts that occurred up until that point. There was no pecuniary bet or wager. It was the swelling of the patronage standard. And the Supreme Court upheld that. So we have fundamentally a decision where a game of chance by lot has been upheld. Here it doesn't matter as much because the real distinction is whether it's habitual in nature or not, but this just goes to show, yes, the court is, and in that statute itself, 849.11, it recognizes card games as games of chance. So it's not just 849.08, 849.11 also says the same thing. When the legislature looks at these different types of games, depending on the flip of the card, using the predominant factor test, we reach the result that these type of games are indeed a game of...
and that's an unanswered question so far, the predominant factor test, whether that is the test to be applied is an open question.
Yes, Your Honor, I believe so. It has been applied by attorney generals, but we don't have a specific court opinion on that to my understanding. So I think...
is the focus, to help me in my decision, the test that's set forth by the courts that affords the flexibility for the state to exercise its police power, if I understand your argument, it would include then trivia nights because it has a randomness of the questions that would be asked. It involves a gift card or some sort of award to the swelled patronage on an otherwise quiet Tuesday night. Is it the state's position that fits within this very seemingly broad test?
the state's position is, and in Blackburn versus Ippolito, this court says you do need to look at it as a fact-by-fact, case-by-case basis, because they can be so different. So, Your Honor's interpretation, the state may determine, we think this is a violation, but they may look at it and say, we think, depending on this trivia game or what has happened or what the prize is, or what incentivizes the individual to come and sit and spend their time there, it's a case-by-case analysis as to whether the elements are met.
So if you're in this business, it would behoove you to seek declaratory relief before you open a business, because you don't know whether or not you're going to be violating this amorphous rule.
You have, I mean, you would theoretically potentially have the ability to do that. I mean, we look at, I guess my position is case-by-case basis. It depends on what you're doing, and if I see that.
So the dispositive fact is indeed what Judge Black has poignantly pointed out, poker.
Well, the dispositive fact is game of chance. And yes, and poker itself, because what opposing counsel is trying to rely on in the Faircloth case is to say, listen, this is really no big deal. These games have been authorized forever. People play poker in the comfort of their own homes. It's really, it's something that's been done for years. That's really not the case with poker. Poker is something that the state, as the actual legislature, has chosen to regulate even in the comfort of your own homes, because you can't play for a hand that's more than worth $10. So to say that the state wouldn't regulate, the state would regulate it if you're in the comfort of your own home and there's no consideration and the hand limit is $10, but won't regulate it for individuals who are going to a bar or restaurant, they're winning prizes that have the value in the thousands of dollars, and the commercial establishment is benefiting from that.
But they're risking nothing. They're risking nothing.
And I would disagree. They're risking their time.
Wait, no. If you're playing in your home for your money, okay, you're risking something. Maybe it's minimal, but you're risking something. These people come and they're risking nothing.
What I would argue is and we may have a disagreement on that fundamentally, but they're risking spending their night at the bar, and it's the same elements of why the state chooses to regulate gambling activities. You get the comity.
What the prohibition is when people are risking money or property, not their time.
And that's part of the court's determination, admittedly. If you go to the level of whether or not it's illegal gambling versus lottery, the court would have to make that determination in this free type of situation, whether a thing of value is or is not the time and the effort spent where you could be doing something else in the game. We totally acknowledge that. But it's our position that those things tie together. Because you have this situation.
Okay, what if the bar had a thing where anybody who came on Tuesday night could write their name on a slip of paper and put it in a jar, and at the end of the night they're going to pick one out and somebody wins a prize? They've just risked their time and they might not win. Is that an illegal lottery?
In the analysis in Blackburn versus Ippolito, the court looked to another jurisdiction that held that same thing indeed was a lottery.
So we've been breaking the law at all the bar functions if you fill out and get a free umbrella from the Bank of Tampa?
Well, the difference is the difference is what the consideration is for who's hosting the function and what they get out of it.
They get free advertisement of someone walking around with their umbrella.
But who's hosting it, I guess, is what I'm saying as well. The bar itself isn't. You would do the analysis of what they're getting coming into the establishment, potentially spending the money, being subjected to the sales appeal, and furthermore, what is the incentive? Is the incentive for the person to come just to get that? The incentive's not there in this situation.
Well, I don't know. Some people will do it.
Some people want to go. Well, some people would like to go out and eat.
Absolutely. And in the rock band concert, people are going to see their band. They're going to go whether or not the band throws out a free T-shirt. They're still going to go. The incentive is the prize itself. And those prizes are of substantial value. And also in the record show you can get more chips by winning and staying and winning. So all of those parts factor into the analysis when you look at the three-part test. Similarly, I mean, I think it's worth noting in this situation, at least.
Well, I want to go back. You just made that statement about the incentive is to do it is the prize. Where does that fit in your analysis?
The prize itself, as a part of the analysis, that's why the person comes to, that's part of the consideration analysis as well. So whether or not someone gives out a free t-shirt, that doesn't affect the consideration the bar gets from you coming to see the band, right? I come to see the band and give that consideration to the tavern, whether or not the band throws out a free t-shirt. The tavern, I don't want to get bar association and bar mixed up, but the tavern can still have these events, and it doesn't reflect on their consideration. It changes with that prize element because that's what's getting you in the door. And that's in the underlying briefing, opposing counsel, or treasurer trust, I should say, had this issue with, well, they're just saying if there was no prize, it would be nothing. When you look at the facts here, when the prizes stopped being offered, the revenues of the bars and taverns went down by half or more. People didn't come because there was no prize. So we've got to look at that as a part of the analysis in determining whether or not something ends up being an illegal lottery or not. Similar to, and you can use that in the trivia analysis as well. If they offer free trivia, if they don't offer free trivia, what's incentivizing it? Is it the prize? Does the prize make a difference? And with that, I'd just like to end on yes, the state does have broad regulatory authority over gambling activities. But, and is there this issue of, is time actually something property? Is time intangible property? When we look at an individual who goes and plays a low-limit hand of poker at a pari-mutuel facility or somewhere else, a non-authorized pari-mutuel facility, they're sitting there, they're hoping to win, they're spending their money, and with the hope of getting something for nothing. And that's the element. They want to get something for nothing. Alternatively, you have someone who goes to Buffalo Wild Wings, they sit, they play, they hope to win something for nothing for the idea of them sitting there and spending their time where they could be doing anything else. Both of those result in that sort of noxious feeling that the state takes towards the attitude of gambling and why it is so heavily regulated and why this activity fits into this case. No matter what it's called, when you look at the substance, that's what the result is. So it's not just pure entertainment. You have these elements that are being met.
Okay.
With that, I will, sorry.
You're going to wrap up because you're at the end of your time.
I am wrapping up. Thank you very much.
Thank you, counsel.
Thank you.
Thank you, Your Honor.
Can you help me understand how we're not bound by Ippolito based on the argument you just heard, counsel?
Ippolito is a lottery case, Your Honor, and this case does not involve lotteries. It involves free entertainment.
Now, that gets back to what I was speaking with the opposing counsel about. Does that depend upon which, the predominant factor test, or whether we adopt that, or whether we go the direction that you were arguing earlier, that if there's any level of skill involved, then it's not a lottery?
Your Honor, the latter.
So that
and the
comes
only
into play.
time,
So and why is your position more tenable?
And I don't dispute that Florida has applied the predominant factor test to determine whether something is gambling or it's not gambling. But the predominant factor test has only ever been used, and the department cited cases from other states where the predominant factor test was used to determine whether poker was predominantly a game of skill or predominantly a game of chance.
Mm-hmm.
And that's because the people in those cases were arguing that it was not gambling at all because it was a pure game of skill, and so it took it out of the gambling statutes, and that's not important for this case. We know we don't have gambling here because we're not risking any money or any property to play.
Let me see if I can frame my concern, and I'm sympathetic to your argument, and both sides. You're doing very well, and this is a very interesting case. But one thing that concerns me is that if the prize was big enough, let's take a situation where a tavern says we're going to offer, a month in Europe or something just crazy elaborate. And I guess it would actually come through the entity putting on the poker game, to where you could draw, say if you had this sufficient, say you had it at the fairgrounds, and you could have 10,000 people playing poker. But under your analysis, that wouldn't be anything that the government has any right or interest in, as long all the other factors being the same. Is that right? In other words, you could think up a situation where you could have just an enormous, almost like what you would see in Vegas, poker tournament, where people don't really risk anything, but the prize is so desirable that it would draw out thousands of people.
And so they wouldn't be risking anything to participate
Right,
in the
they wouldn't be
tournament?
risking anything. But the establishment hosting it would sell tens of thousands of dollars worth of drinks. So it would behoove everybody to do this on a grandiose scale.
I think
My
this
concern is whether, shouldn't the state have the right to regulate that? Wouldn't we as citizens want them to be able to step in and regulate that because it's desirable? Because as council pointed out, we are a state that takes a restrictive view of gambling activity, and so we should interpret these arguments in the most conservative way. And I just want you to address why we shouldn't be concerned about something like that.
Okay, and on this scale, I would say that you shouldn't, because I think
I know
any
this is
business
not
should
that
have
case,
a
but
commercial-
if we do what
So
you're
we're doing
asking and write an
something-
opinion saying, hey, these things are fair game, then that means they're fair game no matter how big they get.
Well, and this hasn't been briefed, Your Honor, so I'm going to try to answer your question
Okay.
as best as I can.
All right.
I believe that if there were some sort of sweepstakes promotion, if it's over $5,000, that the state is already regulating it, that has to be reported to the Department of Agriculture. I also believe if there's going to be a big activity at the fairgrounds, then they're going to have to get permitting for that, and they're going to have to get permission from the city or their county. So it's not like they can just have a promotion and move it from their
Well, I
bar
couldn't,
out into-
take the fairgrounds out of it. I couldn't think of a bar big enough to host what I'm picturing.
But I think, I think in this case, and I don't know that there's a difference between, the size of the bar, if it's a bigger bar, if it's a smaller bar. We have 20 people playing, we have 8 people playing. I don't know that that factors into it. Judge Badalamenti, I will say that you talked about the trivia in Buffalo Bills, and that really is exactly what the department's position here is. They're saying that anytime you spend your time, your effort, if it's inconvenient, and you come in there and you enter into a game of any sort, then if there's prizes awarded, then this is going to cover it. The department is taking it backwards. They're saying that anytime you see a prize awarded by chance for consideration, it's a lottery. That applies to everything. That's going to include everything in the gambling statutes, and I think we can all agree that not every type of gambling is a lottery. There are skills involved.
But
and-
if we were to conclude that the predominant factor test applies and that the predominant factor is that it's chance, would that bring it within the definition of lottery?
No, it wouldn't, because you'd still be acknowledging, even if chance is the predominant factor, you'd still be acknowledging
Some
that there's an
level
element of skill,
element.
which takes out of lottery. And the predominant factor test, as I said, is only important if we're trying to figure out if it's gambling.
Understand.
And we don't even have to get there here because we don't have any risk or money or property on the outcome of the game.
Okay.
I just wanted to mention the state's argument. We know it when we see it. I think that was you, Judge Black, that mentioned that. We know it when we see it.
That was him.
It's vague. Judge Badalamenti, I'm sorry.
I'd like to clear Judge Black's name, it was me.
Thank you. I heard the department's explanation of a game of chance by lots. I still don't know what it is. The Florida Supreme Court adopted a new jury instruction for game of chance by lot this year. I don't know what it means. Judge Van Nortwick doesn't know what it means. So, I would say that if we're going to convict someone under those statutes, no one would know what it takes to violate those statutes.
If we were to write an opinion reversing Judge, was it Rondolino's order in this particular case, what would it say?
It would
Tell me
say-
the holding.
It would say this court declines to exercise judicial activism. It's going to exercise restraint and confine Little River to the lottery cases it was meant to address.
And apply the facts of this case to that reasoning. You've concluded. What's the reasoning?
The reasoning here
Is that poker is not what?
because poker is not a pure game of chance like a lottery is. Lotteries are, as I said before, the most condemned form of gambling in our society because it preys on the weak, it preys on the poor, it plays on the simple. Not my words, the United States Supreme Court words. There's a quote in Greater Loretta where the Supreme Court explains why lotteries are antisocial and why they are the worst form of gambling that we have in our society. So in this case, we have people coming out to play poker, which is a game that's been played by presidents, Supreme Court justices for over 100 years. It's social. People enjoy it. They come out to play the game. And with all due respect, The department doesn't know whether those people came out for the T-shirts for the rock band or they came out to see the rock band. There's no evidence of that in the record anywhere. People come out to play poker because it's fun, it's social, they talk to people, they sit around, they have a great time. Yeah, they win a prize. But in this case, there's no risk of money or property at all. As Judge Kelly aptly recognized, in the games at home, you can risk $10. Here, you don't risk anything at all. If you buy a drink, if you buy food, you get drinks and food. You don't get extra chances to win.
Thank you.
Thank you.
Thank you both.
Good job.